Well, good morning, and thank you everyone for taking the time to join us this morning. I thought we might spend the next 20 minutes or so looking at some of the issues that perhaps are likely to confront organisations that experience breaches of their data that they hold on behalf of third parties, looking particularly through the prism of managing that problem and the subsequent fallout of a data breach. Of course, references to data breach encompass a whole spectrum or a whole range, from targeted cyber hacking to data harvesting, exfiltration, often in circumstances where there's a contractual framework in place designed to prevent that behaviour, to theft of devices containing data, to what is frankly the most usual breach, which is inadvertent breaches by third parties, by employees. My name's Rory Neice. I'm a partner and I'm a head of litigation at Ashfords. And I thought that in terms of unpacking those issues, we might look at 5 subjects. So the first would be, I propose, is triaging a data breach. The second is to take a look at the role of communications following a breach. Then thirdly, to see what lessons there may be for us to learn from the world of product safety and recall. Look then at perhaps 2 aspects of how we might reduce risk of a breach, and then some final thoughts on the litigation landscape and how that might impact on data breach issues. So going into the first of those subjects, data breach triage planning. 5 stages, and I appreciate that that some of this will be familiar territory to a number of you on the call, but perhaps worth briefly looking at each limb in turn. In terms of reporting a breach, we found in advising organisations that have suffered a breach that it's largely a mindset issue. If a breach is not reported, then it can't be dealt with. And the most serious breaches that we've seen, and certainly those that have threatened the survival of an organisation, tend to go undetected or unreported for very considerable periods. Same goes for breaches that result in significant reputational damage, and the TalkTalk breach of a number of years ago, I think, possibly serves as an example. Cultural acceptance that mistakes can be made but should always be reported is probably the initial and first line of defence to ensure that when errors are made or when a breach occurs, there is a reporting system that is actually embraced and used by the organisation. Part of that promotion is clear protocols, but also adopting the message from Ros, clear upstream responsibility at senior management level. Don't delegate at the senior level, own the problem yourself. Detection of a breach is self-evidently absolutely crucial. It's also, I think, in many respects, the most difficult aspect of triaging. Luckily for me, that's an issue largely for our tech experts on the call. Moving on to the second limb, containment. Immediate consideration has to be given following a report on how to minimize the impact of a breach, how to stop the breach, consideration of quarantining or disconnection of certain aspects of an organization's systems. Third-party relationships need to be assessed at this point. And in particular, where is the breach coming from? Is the breach actually being committed by a third party? Or is the organisation being used, again, as Ros has already rehearsed in her segment, is the organisation being used as a gateway into other organisations? In other words, the weaker link. At this stage, very often in terms of containment, the conflict between the need to comply with regulation and the impact on the business itself starts to arise. And that can give rise to quite difficult conversations internally within an organisation. A decision to not comply with regulatory requirements in order to protect what's perceived as the immediate business interests rarely works well in the medium to long term. Third limb, assessment. What type of incident is an organisation facing? To what extent are digital systems impacted? What is the reach of the breach? Are there any parts of the business that are unaffected and that can be quarantined and corralled away from the affected elements? What type of data is vulnerable to having been breached? And in particular, is that data personal data? Is this an ongoing issue? So those are really the initial assessment questions that an organisation would need to ask itself. Then move on to the notification stage, a stage that lawyers get awfully excited about. The general data protection regulations require a reporting to the Information Commissioner's Office within 72 hours of the breach. Other regulators have tighter timeframes. The Privacy Electronic Communication regulations provide 24 hours for service providers to notify of a breach. As many will know on the call, service providers defined as organisations allowing or providing a service that allow the public to send electronic messages, so telecoms, internet service providers, and the like. And then the last stage of triage is evaluation, asking the questions of why, how, and what steps can be taken to prevent a breach from reoccurring. So we move then on to the second topic, which is communications. Communications, in my view, is going to be absolutely fundamental to assessing how a data breach outcome will finally look like. In the pre-internet age, particularly in the product safety, product liability world, decisions regarding a potentially unsafe product would often be able to be taken within a window of perhaps 7 to 10 days, perhaps even longer. In today's environment, data breach, occurrence of data breach may sometimes allow a window of assessment of between 7 and 10 hours. The world has changed obviously significantly, and many breaches are initially detected by the data subjects themselves, those who are affected. They work out that their data has been compromised. And their recourse, well, almost inevitably, is social media. In terms of the ICO, it's well known that breaches involving personal data must be reported. And we're going to look in a moment at how those initial communications of the ICO might look like and how best they may be approached. Similar situation with data subjects. Third parties, including law enforcement, but also upstream and downstream contractual parties and partners, will also need some consideration. But in terms of this slide, perhaps the last bullet point is potentially the most interesting. Is notification always necessary? And the answer is that well, the answers can be surprising, frankly, and are always fact sensitive. And it's an important question for an organisation because notifying, for example, the ICO when notification was unnecessary risks drawing attention to other issues, which there was never any need to. But equally, failing to notify when it is necessary risks prosecution. So I thought of 3 examples. None of which are based on matters that I've actually dealt with, so they're completely anonymous. They're anonymous, but might help us look at that. So the first is a data controller stores data on a backup. The data is personal data in nature. It's on an encrypted USB key. It's kept in the office drawer. The USB is stolen during a break into the office. Is that theft? Is that reportable? Well, so long as the data is encrypted with state-of-the-art algorithm and is secure, then it won't have been compromised because it won't be accessible. In those circumstances, that sort of event may not be reportable. Much will depend upon the quality of the encryption that was used by the data controller. So second Second example, a controller suffers a ransomware attack, resulting in all data held by the controller being encrypted. No backups kept, data can't be restored, but the ransomware's only functionality is to encrypt the data. It doesn't access or exfiltrate the data, and no other malware present. So in those circumstances, is that a reportable event? And the answer is yes, almost certainly it is. But the reason why is because of the loss of availability of data. If backup data sets had been kept, in that example, where the data itself was not accessed by the third party, that may not have been a reportable issue, because there would have been no permanent loss of availability of data to the data subject and the data controller. And then lastly, an example which I think is pretty straightforwardly reportable. Controller manages an online service holding personal data. Cyber attack exfiltrates the data. Is it reportable? Well, yes, it's reportable to the supervising authority and the data subject because it contains personal data. Second slide on communications. A long time ago, a very good advocate told me something which I've always tried to bear in mind. Most people will remember 3 things from a conversation. So if you make 10 points, the overwhelming likelihood is your 3 best points aren't going to make that person's memory cut. So in terms of communications following a data breach, my view is keep it simple. Most people understand that mistakes can be made. What they don't understand or tolerate is the cover-up. So be proactive, engage early, have a plan, or at least explain you have a plan for a plan. Don't mislead, and especially don't mislead by omission. And it's worth remembering, I think, that silence creates a void, and that voids are always filled. So if you have an opportunity to message what has happened, and you are prepared and able to do so, think carefully before declining that opportunity. In terms of the ICO and data subjects, well, they're human beings. The ICO in particular wants to assess us as controllers when we make a report. The aim of that first call or contact, it seems to me, must be to instill confidence in us. So the ICO comes off that initial communication thinking that we have addressed the problem, we have taken ownership of the problem, and that we have a plan in order to resolve it. In circumstances where the ICO comes away with that message, in my experience, it's much more likely that the ICO will have a proactive and helpful approach rather than a more inquisitorial or investigatory approach. Same really goes for data subjects. The comments needs to be more nuanced, but ultimately what data subjects, like all of us, don't like is being messed around, and certainly they don't like being misled. Internal communications, external communications need to be clear and thought through, and should really be controlled and be led by a senior person within the organisation. So in terms of next topic, product recall, lessons to be learned, well, very similar issues arise. Data breach, like product recall, tends to require very important decisions being taken very quickly, oftentimes in an environment where not all of the answers are known. And really, in terms of product safety and product recall, what you see on the screen are stepping stones that have stood the test of time. There has to be clear internal decision making at a senior level. It's back to Roz's point of no delegation, and it is astonishing how often those sorts of decisions attempts are made to delegate them downwards. The organisation and the senior management do need to embrace the problem, moving quickly but surely, ensuring simple external internal messaging. Then the last 2 points really, it's always better to work with regulators, not against them. If regulators think we're working against them, they get suspicious. As soon as they get suspicious, they start investigating with more vigor. Customer confidence, will it always be damaged? Well, in relation to product recall, the history suggests no, is the answer to that. A well-organized, well-managed recall, which is honest and straightforward with its customers, has a good chance of boosting customer trust in that product, in that brand. Again, people understand, I think, that things can go wrong. But what they do expect in those circumstances is a clear plan to put it right, and that involves ownership of the problem. Same really applies to breaches of data in circumstances where a well-organized, well-messaged response gives an organization an opportunity of maintaining some trust with its users, with its consumers, whereas the reverse is also true. A badly organized, mealy-mouthed message which keeps basic and important issues away from consumers will only have the effect of reducing confidence in that brand and in that product. So customer confidence can be maintained, but an organization has to work very hard and very quickly to do that. So reducing risk, and I thought maybe that there were two areas which would be worth looking at. The first is what it says on the tin, data minimization. Only keep the data that you really need, including your backup. And there's reason for that. First of all, the law requires us to do that. The law requires data to be regularly cleansed of unnecessary material. And the law only allows us to keep data for as long as we reasonably need it. And the test of what is reasonable is pretty narrow. So very often what one sees on a data breach is a lot of the data that is compromised is data that the organization simply had no need to retain, hadn't cleansed, and therefore the problem was massively exacerbated by a lot of this old, unused, forgotten about data being exfiltrated from an organization's systems. In circumstances where regular cleansing of data takes place, the reduction in risk is obvious. If there is a breach, the amount of data that is threatened is very significantly reduced. The other point is we see regulators asking these sorts of questions quite early on in the event of a report. Regulators are starting to look at what sort of data is being kept by people who suffered breaches and why. And one can get to a point quite quickly in that process of an organisation having to have some pretty uncomfortable conversations with regulators as to why they have retained data that's clearly unnecessary for the functioning of their business. The second element are contractual terms. Are they the answers? Well, most lawyers, of course, think contractual terms will govern everything and are the answer to everything. It's not actually quite right. Contractual terms don't of themselves prevent a breach. What prevents a breach are the tech solutions and systems that organizations put in place to firewall and protect their data. What contractual terms do is govern the relationship as to why third parties and data subjects are permitting a data controller to either hold data or to allow others to access it. And a sort of a quick case history hopefully might illustrate this. Data Controller is an online service. It contains a database of job seekers who upload CVs to the database with personal data. In doing that, they consent to third-party access, for example, recruiters. Recruiters are interested in the database because they hold the job positions from their employer clients, and they're trying to marry the position, of course, with a potential employee. Recruiters contractually agree with the data controller that they will not data harvest. So they have a contractual framework in which they agree the basis on which they can access data from the site. So those contractual terms record the relationship and reflects the permissions given by the data subject when they upload their personal data onto the system. Harvesting, of course, then occurs because some recruiters will simply choose to ignore their contractual obligations and agreements. They then contact data subjects offline. Data subjects immediately put two and two together and work out there's been a breach, go onto social media and start complaining. It's personal data, it's reportable, it gets reported to the commissioner. So did the clear contractual terms prevent the data harvest? Well, obviously the answer is no, it didn't. In the example I'm thinking of, in that particular example, there had been available a tech solution that would have prevented the ability of third parties to data harvest and would have also sounded an alarm had someone tried to do it. This hadn't been put in place. And the reason I think why that wasn't put in place in that particular example was the controller placed too much reliance on a contractual framework that they did have in place. Contractual terms deliver the framework around which third parties can access data. The technical solution that had been available on known to the controller, had it been used, would have stopped the breach. So in those circumstances, I think the lesson from that example is focused on prevention rather than cure. In this instance, the tech solution would have prevented the problem. The legal solution, whilst it has a value, in this case, in reality, its value was it gave the controller a route to bring a claim against the recruiter who harvested the data. But that really is shutting the stable door after the horse has bolted. So don't forget, prevention always better than cure. So the last area, if I may, I'd like to look at briefly with you is the litigation landscape. Now, if anyone on this call has never received a text or email or phone call inviting you to make a PPI claim, I'll frankly be amazed. PPI has been a gravy train for claims farmers, and that train has now come into the station and is rapidly coming to an end. What are those claim farmers likely to do we think? Enjoy the fruits of the last 5 or 6 years, or look for the next PPI? I have a sneaky feeling that it's going to be the latter. And if it is, what do we think is the next PPI? Well, I think there are two candidates. The first is equity release. The second is data claims. And of those two, for me, data claims is favourite. And the reason is pretty straightforward. They're very easy to bring. They can be processed in bulk. It's not rocket science. They can be dealt with by non-lawyers, so they can be dealt with cheaply. And they're likely to produce years and years and years of work. So what does that mean then for organisations that suffer a data breach? Well, the reality, it means that they face potentially a very significant and in some cases a business-threatening claim at the end of the breach process. To take an example which may or may not become reflective of reality in future years, let's imagine a data breach involving the personal data of 100,000 individuals. And let's say that 10% of those people decide to bring a claim in circumstances where we're in the same environment we were with PPI, where everybody understands that there are systems in which a claim can easily be bought, where people are being bombarded with messages suggesting they bring a claim. Let's say that each of those claims has a value of roughly £1,500. That's a £15 million problem for a organisation. And even if those claims were right at the bottom end of what they're worth, say £300, it's still a £3 million problem. And if claims farmers do, as I suspect they will, turn their attention to data claims, then that is really going to be the motivation, I suspect, over time for people to really focus on prevention rather than cure. The difficulty is, I suspect, that there will be a number of businesses that will not survive that type of attack from claims farmers. And so some difficult lessons will have to be learned by a few before the many take on board the message. So that really is where I am in relation to the sort of fairly brief canter through the topics that I've looked at with you. But if I could have one message to leave, it is that steps that can be taken to prevent a breach, whilst those steps will only ever be recognised in the event that a breach has occurred because nobody did anything to try to stop it. Those steps are steps which, certainly from an individual who deals with the other end, we would always recommend a client to take. The difficulty in terms of selling that message, I think, is if you take the steps and you have good preventative measures and you never suffer a breach, I suppose you never see the fruits of your labour. But the reality is, for those who don't, the landscape they face post-breach can be very difficult. So thank you for your time and for listening.